hosting this press conference on Bill 3. And just over to you, Minister.
Thanks, Ethan. Morning, folks. Well, I guess not morning anymore. It's afternoon. And speaking of it being now afternoon, just to start off with a mea culpa and an apology to everyone who called into the embargo tech briefing this morning for the delay in getting you the news release and the Q&A. Please also accept my apology for the rescheduling of this press conference. Finally, another housekeeping comment. Peter Dobby, who is the property rights and farmers advocate, will be available for further media interviews. If you'd like to speak to Mr. Dobby, please reach out to Ethan after this press conference. Thank you. I'm pleased to announce Alberta's government is introducing legislative changes which will protect the property rights of Albertans and to fulfill a 2019 United Conservative Party platform commitment. Albertans value their land. They work hard to earn it. They work hard to maintain it, and they work hard to improve it. It's their home, their place of relaxation, and their recreation. And for some Albertans, like our farmers and ranchers, the land is also their livelihood. Now, given how hard Albertans work for their land and how important it is to them, the law should be there to protect property owners' rights. And the Canadian Bill of Rights, passed in 1960 by Prime Minister Diefenbaker, protects, quote, the enjoyment of property and the right not to be deprived thereof except by due process of law, end quote. Unfortunately, the Canadian Charter of Rights and Freedoms, which was enacted in 1982, does not enshrine property rights for the individual. This reality means that provinces, which have the constitutional authority over property, must step up and defend property rights. So today, Alberta steps up by introducing a bill to abolish adverse possession and to restore the rights of Alberta's property owners. Under current provincial law, it's possible for someone who has been squatting on land to go to court and potentially claim ownership. It's called, here in Alberta, adverse possession, more commonly, as I said, known as squatters' rights. Later today, earlier this afternoon, I introduced the Property Rights Statutes Amendment Act of 2022 in the legislature in order to remove adverse possession. Now, this act, if passed, will protect property owners' rights by ensuring that those who are not the registered owners of a piece of property can't take ownership of it by going to court. It would save landowners from the worry that they currently have of losing their land and needing to monitor it to prevent people from taking possession. Today is not the first time that a bill has been introduced in Alberta's legislature to abolish adverse possession. There have been previous attempts to make this change through private members' bills, but none of them have been successful. And I'm hoping this time will be different, because Albertans have been saying that they want this change for over a decade. The MLA Select Special Committee on Real Property Rights consulted extensively with the public about property rights, and during those consultations, they received multiple requests to abolish adverse possession. And they recommended in their report in June of 22, abolishing adverse possession. Now, 6 years ago, the Property Rights Advocate Office urged government to abolish adverse possession, and in 2020, the Alberta Law Reform Institute recommended the same thing. Alberta's government is responding to these recommendations from these three different sources with the legislation that was introduced earlier today. Now, if passed, this act will bring peace of mind to Alberta's landowners. It will allow them to use and enjoy the land that they rightfully own without having to worry about whether someone can take it away. Updated legislation would send a clear message that there is nothing to be gained from squatting on someone's land. By introducing the Property Rights Statutes Amendment Act 2022, Alberta's government is strengthening property rights and giving landowners the security of knowing their land can't be taken away from them. And so thank you very much for your time. I'm happy to now bring up the chair of the Select Special Committee on Property Rights, R.J. Sigerson. R.J.
Thank you, Minister Shandro. I'm pleased to be here today to support the introduction of Bill 3, the Property Rights Statutes Amendment Act 2022. As Minister Shandro has stated, this legislation will abolish adverse possession, more commonly known as squatters' rights. This is an important part of the 2019 UCP platform, which will bring peace of mind to many landowners. As the chairperson of the MLA Select Special Committee on Real Property Rights, I heard directly from Albertans across this province regarding this exact issue. The recommendation to update this legislation was an important part of the report which the committee published in June of this year. Alberta is one of the only few jurisdictions in Canada that still have this archaic law on the books. Landowners have been asking us to abolish adverse possession for years, and today we are here stepping up to ensure that their property rights are protected. There are many challenges which face the agriculture sector, and thanks to our United Conservative government, this is one battle which they will not have to fight. Protecting property rights helps landowners, farmers, and ranchers focus on what they do best, managing their businesses and putting food on the tables for consumers. Rather than tying up landowners' time in litigation protecting their property, it should be a given that their property rights are protected. This is another good example of our government working within provincial jurisdiction to exert our full authority to protect the best interests of all Albertans. I'm proud to be here today in support of this legislation. Together with my UCP caucus colleagues, we will continue to fight to ensure the best interests of Albertans are always protected. Thank you.
Thank you, MLA Sigurdsson. We'll now enter the question portion of this press conference. As with all of these press conferences, reporters will get one question and one follow-up. And please state your name and organization when making a question. We'll start with the questions here in the room.
Hi, Minister, it's Grant Thompson of the Star. I have a question regarding Bill 1 and the amendments. Last week, you brought the bill in. Critics and the media were watching this saying there's a Henry VIII clause in here. This is overstepping bounds. It's bypassing the legislature. And at the time, the government was saying we were wrong. We were getting hysterical for no reason. And now the government is bringing in amendments to do away with the Henry VIII Act, or the amendments. So what happened? Why did you have to go back and amend it if we were so wrong last week?
Well, I think folks received feedback about a request for this change, and caucus had heard it. We had a conversation at caucus. People are looking for that amendment. I understand that there has been a press release as well that's come from caucus announcing that there will be an amendment related to that. Previously at INS, sorry, you had asked me at INS if I thought it was going to be today, and I apologize. I didn't know the timing of it, but I understand now it probably, it depends on when it gets to the committee of the whole. So if that's tomorrow or Wednesday, maybe that'll be introduced, and so the folks will be able to see how it's being proposed to be amended at that time.
I'm sorry, but again, you were saying we were all wrong last week when we were critical of it. What happened? Like, who drew this up? Why were you so wrong then last week if we were the ones that weren't wrong?
Well, I think folks have asked for this clarity, that the previous, the way it was drafted had a confusion, obviously, because some folks had interpreted it one way, and all I can say is that now it's being proposed to be amended. We've taken that feedback from Albertans, and again, this is now has been announced by our caucus to have amendments coming forward this week to address those concerns that people had.
Minister, I'm going to ask that same question a third time, because this is not a drop semicolon, sir. You gave yourself cabinet sweeping powers to rewrite laws behind closed doors. And now you're saying that was never meant to be in there. So I think a mistake of that magnitude, sir, don't you not, yes or no, please, do you agree that that kind of thing deserves, Albertans deserve an explanation for what went wrong?
I think Albertans deserve clarity. I think Albertans deserve to understand what is proposed to be amended in a directive, in a resolution from the Assembly. They've asked for that clarity, and they deserve that clarity, and that's what our caucus in Premier's legislation. Premier's legislation has now been tabled at first reading. It's now in second reading. And caucus has now heard from constituents and Albertans. There's an interest in having this amendment. I'm pleased as counsel to executive council to be able to assist in making sure that those amendments for that clarity are drafted.
Okay, so you've been asked 3 times, sir, for an explanation. You've refused 3 times to give an explanation. Can you explain to Albertans why you will not tell them how this mistake was made?
Well, Dean, I'm not going to characterize it as a mistake. I think that there was a first draft of the bill. And obviously, there were a lot of questions about it, even at the press conference when we were here in this room just last week. Folks had questions, and they're asking for clarity, and we're taking that feedback. And I understand from caucus that there will be amendments proposed to Premier's legislation.
Why is it going through caucus? Like, why not? Why is it the government amending the bill? Why aren't you amending the bill, or the Premier, I guess? Like, I don't understand. It's a government bill, so why is caucus going to be, like, what's the plan here?
Well, in committee of the whole, all of the members can propose amendments in committee of the whole. I mean, we've had conversations internally as caucus, and there's an interest in providing better clarity in this legislation for Premier's bill. So of course we would always have conversations. We meet on a weekly basis to discuss our legislative agenda, discuss topics of the week. So we've had those conversations ourselves as caucus. There's also been conversations at Executive Council and an interest in providing greater clarity in the amendments that might be proposed in Committee of the Whole.
You keep saying the word clarity. I mean, you just left it out of the bill in the first place. Like, clarity to me suggests that, you kind of got the wording wrong. It just wasn't there, Minister. It just wasn't there. So again, like, how was this left out in drafting the bill?
Well, again, for me and my role in doing this is to provide legal advice to Executive Council. I am counsel to Executive Council, making sure that I'm providing options to Executive Council, what might be possible for each decision point, what the opportunities are at each of those decision points, what the options are, the advantages and disadvantages of each, and then we make decisions as Executive Council. And then from there, our process is to take legislation to caucus before it hits the floor, and folks get an opportunity there to review it. People have heard feedback regarding this one particular part of the bill. As we said, look, there was always opportunities for this to begin with in an open and democratic forum through a resolution that's debated and passed by the legislature. But folks are looking for an amendment to the legislation to ensure that it's not going to be legislation that would be changed unilaterally after the resolution. And I look forward to seeing the amendment hit the floor of Committee of the Whole.
Okay, we're now going to take a few calls, few from the lines. So operator, could you please put through the first caller?
Yeah.
Jerry Tate, Globe and Mail.
Hi, Minister. Thanks for taking my call. This was to be the Premier's signature piece of legislation. She campaigned on this. This was your first bill introduced in the new setting. How can Albertans trust that you guys are working through legislation in a thoughtful manner when this series of amendments comes less than a week after it was proposed?
Well, because I think it's because folks are listening and wanting to be responsive to questions that constituents have, and being open-minded to amendments. I think it's by being open-minded to amendments that the answer is there.
It's true that bills are amended all the time, and what part of the process is often a consultation prior to that. Why was there no consultation? We still see Indigenous groups who are upset. The business community has been pretty vocal. Why was that just bypassed in putting this forward? It looks like you're rushing it.
Well, I think it's been a piece of legislation that's been debated for months. This began during the leadership contest. There was robust debate. There's been many iterations of what's being proposed for this legislation. And I think the many iterations have taken the feedback as people have responded to some of the concerns, wanting to ensure that it is constitutional, wanting to ensure that it does protect the Indigenous rights of our Indigenous communities, and wanting to ensure that it does not adversely affect job creators from scaring out investment or opportunities to create jobs in the province. I think getting that feedback over the last few months was the consultation process for us to see the different iterations up until the point that you see it now.
Thank you. Operator, please put through the next call.
Tyson Fedor, CTV.
Hi, Minister. Different topic here. A new analysis poll came out today with most Canadians, about 2/3, supporting the use of the Emergencies Act by Ottawa for the convoy. On the prairies, though, that was much different. It was more of a 50-50 split. Just wanted to kind of ask if your government has maybe learned or, I guess, plan to do anything differently when responding to these large-scale protests in the future. We do know that your government asked for some support from Ottawa before the Emergencies Act was invoked. So have you learned anything, or is there anything different that your government would do when protests like these occur in the future, potentially in the new year?
Well, I think law enforcement always learns from every large-scale incident that occurs. And but look, the Emergencies Act, and just going to the premise of your question, wasn't used here in Alberta. So I mean, we have to be clear about that. But obviously, we want an opportunity for law enforcement to be able to protect the rights of Canadians. We want them to do it in a safe way, and a way for them to be able to come home safely to families at the end of the day, which I think was the focus for all those in the Joint Command during that time. And I thank those who were involved in leadership in law enforcement for doing it, doing their best to protect the interests of Canadians in a way that ensured that their folks came home safe to the families every night.
Thank you.
No follow-up from me.
Okay.
Okay. Operator, please put through the next caller.
Alex McQuaig, Western Producer.
Hi, Minister. Good afternoon. Just regarding the Real Property Rights Committee and its recommendations, this is one of the recommendations. What is in store for the rest of the recommendations that came out of that committee?
Sure. Actually, for that, I'm going to ask the chair to come up and maybe speak to that.
So definitely really excited about Bill 3. When we toured around the province, of course, adverse possession was the primary issue of concern. So I'm really happy the minister is addressing that bill right here and right now. It shows our commitment to listening to Albertans to protect their property rights. With that, there are other recommendations that are still ongoing that resulted as that work. I know that I'm working with the departments right now to continue the fulsome moves that we need to ensure to protect property rights in Alberta, and I look forward to continuing that work. And right now, I just want to focus on Bill 3, which I think is the really critical piece. This is a piece of very archaic law that has been around. We heard it unanimously every meeting we had, the virtual meeting here in Edmonton, and definitely on the written submissions. This was the leading issue that people wanted dealt with. So I'm very happy to see Bill 3 on the floor of the Legislative Assembly and look forward to supporting it through the process and getting it passed as soon as possible.
And maybe I'll say that. And maybe just to say as well that the ministries who are affected by the recommendations, the other recommendations, are looking at that and coming forward with proposals to their respective ministers to see if there's anything further that could be done with those recommendations. And this one, look, I think there's a reason why this took so long, because for us to be able to address adverse possession, it's not easy. It's 3 different pieces of legislation in 2 different ministries. So for folks to wrap their heads around how this could be amended in a bill has been something that past governments have grappled with. So anyways, thank you.
Thank you. Do you have a follow-up?
Yeah, I do. Just regarding the minister's comments that the charter failed to enshrine property rights for the individual. My understanding was during the negotiations by the provinces for the charter that the provinces want to maintain jurisdiction for property rights. Has that changed at all in the last 40 years?
No. No.
Okay, thank you. Thank you. Operator, can you put through the next caller, please?
Darren Levitt, Toronto Star.
Hey,
thanks for taking my question, Minister. I saw you tweeting about the federal gun bill today. I wanted to ask you about some of the pushback there and, see if you had plans or ideas for using the Sovereignty Act, assuming that it's going to, continue to have that piece that allows for the cabinet to direct public entities and, use that to push back against the federal gun bill in its current form. Would you direct police forces in Alberta to not enforce that law should it come to that?
Good. Thank you for that question. So first of all, I'll say when it comes to the Sovereignty within the United Canada Act, Bill 1, it's not passed yet. And we're not through, and we're just taking questions about committee of the whole and what potential amendments might be there. I think we have to see first what gets passed by the legislature and then seeing how it might address these issues and what the opportunities might be. But I think that there's a lot for us to learn and what Saskatchewan is doing right now with their firearms legislation to be able to address the concerns with, I think the minister in Saskatchewan told me that her chief firearms officer in Saskatchewan estimated about 10% of folks in Saskatchewan would be criminalized overnight with the passage of this bill. So they obviously have a lot of concerns. We do in Alberta as well, and I think there's opportunities for us to learn and take a look at what is happening in Saskatchewan. So there's a couple options there to start off with.
Did you have a follow-up?
Yeah. Why not use this act, though, as a deterrent for that bill? I mean, if Premier Smith has already said, the Sovereignty Act has already achieved what we want, and that's getting Ottawa to respect our provincial jurisdiction and not, cause harm in Albertans. And so I'm just wondering, why not come out and say, this is something that, we would look at using the Sovereignty Act to fight against?
Possibly is what I said, and it's going to depend on what ends up being passed by the legislature. So once something is passed, once there is a piece of legislation, then I think there needs to then be an analysis on what the opportunities might be at that stage. But I think we just have to put the cart before the horse, or not put the cart before the, yeah, that's how the saying goes, right? Not put the cart before the horse. Yeah, don't put the cart, yeah, do not. Okay.
Thanks. Are there any other questions in the room?
Yes, I just want to clarify. You mentioned that there would be 2 amendments tabled to, as the UCP caucus statement said. Are you considering another one to address the Indigenous people's concern? I know Minister Rick Wilson said that they want him to do it, but it's not clear what yet. So are you holding off to maybe table a third addressing that?
Well, I can't speak for caucus. Look, Rick does an amazing job in being responsive to and listening to our Indigenous communities. I think if folks are looking at how, I think it's in section 2, 2 sub C, I can't remember, sorry, I apologize. Michelle, you know this legislation. But I think if there's an opportunity for someone to say, look, this is the way it's drafted now, this is what we need to change. Obviously what happened with the drafters is looking how Indigenous rights are protected in other pieces of legislation and using specifically the terms derogation and abrogation. If folks think that's not strong enough, of course, I'm sure Rick would be happy to get that feedback and then pass it on to Executive Council. But I just haven't seen any of that specific feedback yet. I think it's been general so far. And but as I said, Rick is very passionate about listening to and make himself available to those communities.
It doesn't give a lot of time to, stakeholders to, suggest those, amendments if they have specific ones or, corrections that they would like to see in the law. So why not pull it back, do proper consultations, and maybe table it again with amendments incorporated in the spring?
Well, I can't speak for caucus. I'm the Minister of Justice giving advice, giving legal advice to Executive Council and to my caucus. And how Executive Council ends up deciding, or how caucus decides. Now it's in second reading right now, I think, still, until tomorrow or Wednesday. And then when it gets to Committee of the Whole, I'm just one member of caucus, I suppose. So, but I'm happy to be one of many members of this caucus who are listening to constituents and making sure that that feedback from constituents is heard.
Did you recommend to Executive Council to hold those public consultations?
Well, look, my advice to Executive Council is privileged, yeah, so I'm not going to specifically talk about any legal advice I gave to Executive Council.
Minister, you said that the changes or the amendments that are being brought forward by caucus, whenever they're officially brought forward, were born out of conversations and you're listening to feedback. Did nobody in caucus or cabinet, before this bill was tabled on Tuesday, point out these two things could be problematic? Did nobody raise concerns about that?
I think if I answered that, I'd be breaching caucus confidences and cabinet confidences, so I won't be speaking to that. Yeah, I'm answering that specific question.
Okay, and why specifically, I mean, Indigenous groups say that they weren't consulted prior to the tabling of this legislation. Why weren't they consulted?
Well, to the extent that they were, I suppose would be through Indigenous relations. I think that'd be better if you don't mind. I'm not trying to punt it to somebody else, but I'm punting it to someone else. Sorry about that. But if I could direct that to Indigenous relations and allowing Minister Wilson to answer the extent that they were, and the reasons for the extent of that consultation.
Sorry, Minister, I have to ask though, you're saying that I'll go back to caucus. Who's driving the bus here on this bill? It sounds like if we want to find out any changes to the bill, we should be going to Brad Rutherford. I mean, it's cabinet that steers this bill. I mean, it's
a government bill. It's Premier's bill, and
there's still outstanding concerns, sir, about. I mean, Jody Gondak was on Friday saying, you know, this is way over bounds. I mean, municipalities don't know how to operate. I mean, that's still in the bill. So where do people, if they still have concerns about that part of the bill, do they take it to you? Do they take it to caucus, to Brad Rutherford? Who's actually in charge of this bill, sir?
Look, Jyoti or any Albertan who has feedback for me to bring to Executive Council, my door's always open to Jyoti or any municipal leader. It is Premier's bill. It's Bill 1, but of course, happy as legal counsel to Executive Council to listen to feedback and make sure that folks at the table are getting that feedback.
It sounds like cabinet's hands are tied unless caucus tells them what to do.
No, I don't agree with that.
Well,
but
that's what I'm trying. I think Albertans need to know, how does this work here? Who's making decisions on what this bill will look like?
No, but I think the answer is there's been a press release. And it's been announced by caucus that somebody is going to be coming forward with amendments in committee of the whole. We just can't speak to it yet because it hasn't been tabled yet. So I think if I spoke about it, I think I'd be breaching caucus confidences. But there are opportunities for very soon, from what I understand from the press release, for those to be tabled. And I'm sure I'll be happy to answer questions at that time, Dean. By the way, I'm jealous of those braces, by the way.
Minister, who actually wrote the was it done by government lawyers? Who actually wrote it?
LCO, it's called Legislative Counsel Office. So it was. They are technically folks who are lawyers within JSG, now Justice. So JSG, the folks, I'm not sure how many drafters there are in the department, but they began after October 6th working with Premier Designate at that time to be able to get feedback from her and her team and trying to translate, because there were different iterations of the idea of the sovereignty within the United Canada Act, and be able to get that advice to provide options. And then it went through the typical process for legislation, going first through a policy committee process, going to cabinet, then a gate check, again, that's been added by Premier at the end, at caucus, where caucus reviews one last time, and then goes to Legislative Review Committee, which includes private members, but mostly cabinet members.
Then after all of that careful work, you're yet amending it less than a week after you brought it in.
Well, there's lots of times, lots of examples where legislation hits second reading, and I mean that's the whole reason why we don't have just one reading. Or, you know, like some municipal councils, they'll do 3 readings in 1 hour. We have a process to make sure that legislation has an opportunity to have it tabled. Folks can see it, opposition can see it. Although opposition did vote against it before it even got tabled in first reading. But then there's a conversation, a public conversation, seeing what's been drafted and getting advice. So that's how it's supposed to work. I think that's why we have those 3 readings and we have committee of the whole.
But then you read the act and you thought it was fine last week and you saw it.
I've given legal advice to executive council about what the options are and what the advantages and disadvantages are for the various different decision points. I'm one member of executive council that votes on it, and I'm not going to speak specifically about one particular decision point and what my advice was on that. I think that would be breaching caucus or cabinet.
You're
competence.
aware, Minister, when you introduced the bill on Tuesday, that there was a clause granting cabinet sweeping powers to rewrite laws behind closed doors. Were you, I mean, that's the question now, because no one's really sure if you guys even understood your own bill. Did you guys understand that?
Of course, the bill was understood, and I think the feedback that we've received is that folks had questions, they're looking for clarity, and we're pleased to provide opportunities for clarity in committee of the whole with further amendments.
Okay, thank you, everyone. That's all the time
surprised?
we have for today. We'll
Are
have
you
to call.
surprised by the reaction of the public to that bill?
Well, look, I think that this is a new conversation. I think it's so for us to have a public conversation about a piece of legislation that provides a provincial government and a legislature with a new opportunity to protect provincial jurisdiction. The same as Saskatchewan, though, right? The intent of this is the same as Saskatchewan First legislation, and so some of these opportunities are going to be new, and it's helpful for us to have that public conversation at second reading, at committee of the whole, and with Albertans to get that feedback.
Or are you surprised?
I think that it's not a matter of being surprised or not surprised. It's a matter of we table legislation and we expect to have robust and open conversations. We expect to have an open and democratic process for passing legislation. And, for all of us who, I guess there's not 87 of us anymore, 85 of us, the 85 of us who are in the room, to be able to have that robust and open debate is a good and healthy one. So,
Thank you, everyone. That's all the time we have for today.
Thank you.
Thanks, everyone.
Thank you.